So everybody, okay. This moment of a motion.
Yes, no, we move for directed verdict on all counts. We don't believe there's been sufficient evidence to show that any of the counts were applicable to Joseph Rosenbaum. There's been absolutely no evidence that he was involved in any way in any of the counts that enumerated that are account for him. And with regards to Jennifer Rosenbaum, we similarly move for directed verdict on the grounds that there's not sufficient evidence to point to her as being the person who committed any acts of violence against Leila.
All right, thank you.
Thank you. I think the easiest way to address this is to group some of the counts together. So I'll be talking about counts 1, malice murder, count 2, felony murder, count 3, aggravated assault, count 4, felony murder, count 5, cruelty in the first, count 6, felony murder, count 7, aggravated battery at the same time. They all involve the death of Leila Daniel on November 17 of 2015. First of all, the date of the incident was testified to by numerous people. The date of death by Dr. Evans, he called the time of death. Dr. Darisav just testified that the cause of the death was blunt force injury to the abdomen, pancreas, liver, and small intestine. That was gone through in detail as to each of those items. So I believe there's sufficient evidence as to those counts. It was also indicated that the only two people in the home at the time were Jennifer Rosenbaum and Millie Place. Millie was upstairs. The injuries occurred within an hour of the symptoms being visible to the individuals in the home, which puts the only two people in the home as being Jennifer and Millie.
All right, that's counts 1 through
That's counts 1 through 7.
7. Would you like to make a response to 1 through 7?
No, 1 through 7, my response would be that there is insufficient evidence. I think, as came out of the state's presentation, that Joseph was no evidence that he was at the house at the time within an hour of the time this occurred. So, with regards to second-degree murder, there is no evidence of that.
Second degree is count number 8.
Yes, I haven't addressed that yet.
All right, so as it relates to counts 1 through 7, the motion for directed verdict is denied.
Your Honor, as to the next I will discuss is counts 8 and count 9, murder in the second degree and the underlying cruelty in the second degree. Those apply to Joseph Rosenbaum. As noted earlier, the cause of injury in this case was blunt force trauma to the abdomen, pancreas, liver, and intestine. The key factor in these two counts is that the defendant was negligent in leaving the children in Jennifer Rosenbaum's care, knowing that she had previously abused them, specifically in this case, Leila. We get that information, that evidence comes from, first of all, Millie's testimony. She indicated that when Jennifer would spank her and Leila with a belt on their skin, it occurred in the bedroom. The defendant was present. Defendant Joseph was present in the room. I asked her, what was he doing? She stated nothing. I then asked her, was he awake? And she said, I asked her actually, was he asleep? She said, no, he was awake. So we clearly had knowledge that this abuse was going on. As well, in Millie's interview, she indicated that when they had bruises, the defendant, being defendant Joseph Rosenbaum, would put some cream on her bruises, and that cream was smelled like old people, and was icy and hot, and that he put it on the bruises, not Jennifer Rosenbaum. Again, him being aware of the injuries to the children. This was also corroborated by a picture from CSI where we saw that there was that icy hot cream in the defendant's bedroom. We also know that on the specific date of the incident, the defendant was caring for the children. He was responsible for the children up until Jennifer Rosenbaum came home. There was evidence that he had taken Layla to the bathroom at one point. She was not potty trained. She was still in diapers and pull-ups, which means that he had to have been assisting Layla in using the bathroom. And there's no way that no one would have not seen those injuries that were on Layla's body at that time if they viewed any part of her back or front. There's also indication that from Millie, when she spoke to her therapist, Ann McCullough, that she heard Jennifer and Joseph to kill Layla, and this was done during an argument, whereas Joseph making the comment to kill Layla, it can be inferred that there was an argument that if they were arguing about the abuse that Jennifer was inflicting on the children, and Joseph was warning her that she was going to kill Layla if he continued doing so. So I believe there's sufficient evidence to show that he was aware of the injuries, and he didn't do anything to protect the children. He was a caregiver. He was responsible for these children. He was the foster father. He took part in caring for them, bathing them, changing them. He knew what their had to have seen their bodies. These were young children who need help in the bath, need help going potty, and he essentially turned a blind eye. So I believe there's sufficient evidence to go to the jury on counts 8 and 9.
Response?
With regards to those counts, there is no evidence that he knew the bruises were inflicted in any way by Jennifer Rosenbaum. There is no evidence of that. Simply putting cream on bruises is probably the natural thing to do. You see bruises on a child, you assume bruises occurred as a result of play. You don't know anything different. With regards to Millie's statement that he stood by while she administered spanking for the belt, first of all, we would contest the veracity of that, but this is not the place to do it. But assuming that what she says is correct, that does not, this is corporal punishment, which is permissible in Georgia. They have not been able to tie any of the extensive bruising to Joseph. They have never been able to say that he saw any of the extensive bruising. And for that reason, Your Honor, I think one of the main, to show neglect, they've got to show that he knew what he knew, and there's absolutely no evidence that he knew of anything.
The motion for directed verdict as to counts 8 and counts 9 are denied.
Your Honor, as to counts 10 and 11, those are the injuries, the blunt force to Layla's head done by Jennifer on November 17 of 2015. Dr. Darasov just testified that those were acute and that they occurred on the day of the death. And therefore, they were in relative to the time where the other injuries occurred. So I believe there's sufficient evidence to go to the jury on those 2 counts as well.
Any response?
We stand on our motion.
Motion is denied as to those counts.
Your Honor, to counts 12 and 13, again, aggravated assault and cruelty to children. This is both Jennifer and Joseph charged on November 15, 2015 with blunt force to the child's head. Dr. Darasov testified that those abrasions on her head were starting to scar. They were white, had white edges, and that they were a few days old. Therefore, they fit the time period, were different, happened at a different time than those that occurred on November 17 of 2015. By all accounts, even Jennifer Rosenbaum's statement, the only 2 people that were caring for this children in the 2 weeks prior to Layla's death were Jennifer and Joseph. Therefore, I believe there's sufficient evidence to go to the jury on counts 12 and 13.
Any responses to 12 and 13?
No, stand on our motion.
All right. It's denied as to 12 and 13.
As to counts 14 and 15, aggravated assault and cruelty to children in the first degree, both defendants are named in these two counts. It's blunt force to the child's head. This information comes from numerous witnesses who testified that they saw bruises to the children, that they saw specifically that they were, one injury I believe happened at, someone observed an injury at Noah's Ark on October 17 of 2015. Another, I believe one of the gym tech individuals said they saw injuries on November 2nd of 2015. This is also Dr. Darasah did indicate that the injuries to Layla's head, there was actually 3 different time periods, 3 different time ranges that happened on 3 distinctive dates. So we know that we've got November 17 as being acute, November 15 would be subacute, and then as to counts 14 and 15, those would be older than the previous injuries. There is a date range, but I'd also like to point out as to counts 14 and 15 that we are asking for the charge that the dates are immaterial. We did narrow them down as best we could, but we can't pinpoint the exact date as to the older injuries to the head.
Response?
Judge, you just stand on our motion. Just would note that testimony was that the injuries could have been weeks old, and that necessarily does not place them in the care of Jennifer and Joseph Rosenbaum.
All right. That motion is denied as to 14 and 15.
Your Honor, I'll address counts 16, 17, 18, and 19 at the same time. 16 is aggravated assault. Defendant is Jennifer on November 17 of 2015. That's blunt force to the child's back. Count 17, cruelty in the first degree. Defendant Jennifer, November 17, blunt force to the child's back. Count 18, aggravated assault, Jennifer and Joseph, November 15, blunt force to the child's back. And 19, cruelty in the first. Jennifer and Joseph are named in that count, November 15 of 2015. All 4 counts involve the injuries to the child's back. As Dr. Darasah testified, some of those injuries from the back were fresh injuries within, I believe, like an hour or so before the child died. And there was also some healing injuries. There was a lot of discussion about the different colors and the redness to the back, as well as the more different colored ones closer to the neck, and how those injuries did not occur on that same date. So I believe as to count 16, 17, 18, and 19, there's sufficient evidence to go to the jury.
Any response?
Your Honor, you stand on our motion.
Motion is denied as to 16, 17, 18, and 19.
The next 4 charges are counts 20, 21, 22, and 23. They all involve blunt force to Layla's chest, abdomen, hip, and torso. Count 20 is aggravated assault, charged Jennifer, November 17, 2015. Count 21 is cruelty to children in the first degree, charges Jennifer, November 17, 2015. Count 2, aggravated assault, charges both defendants. That occurred November 15 of 2015. And count 23, cruelty in the first, charges both Jennifer and Joseph on November 15 of 2015. Again, Dr. Darasah talked about the injuries being new, acute, having occurred on November 17, 2015, specifically the injuries in the chest and the abdomen, the liver laceration, And she also indicated that there was an older liver injury. It was healing. She also said there was a lot of iron in it, so she knew it was a few days to a week old. She also talked about the abdomen and the small intestine and the bruising of the diaphragm. So there was evidence as to old and new injuries either being on the date of Layla's death or being a few days prior. We've also charged it as torso, chest, abdomen, and hip, and means or, so if the jurors find either one of those, it would be sufficient to convict on those counts. So I believe there is sufficient evidence as to counts 20, 21, 22, and 23 to go to the jury.
Any response?
Stand on the motion.
Motion is denied as to 20, 21, 22, and 23.
Next is counts 24 and 25. This has to do with the blunt force to the pubic and vaginal area of Layla. Count 24, 25, 26, and 27. That all has to do with bruising to the vaginal and pubic area of Layla. Count 24 is aggravated assault. Charges Jennifer, November 17, 2015. Count 25, cruelty in the first. Charges Jennifer for November 17, 2015. Count 26 is aggravated assault, charging both Jennifer and Joseph with a date range of October 20th to November 10. And count 27, cruelty in the first, charging both defendants with a date range as well of 10/20 to November 10. I believe that Dr. Darasad testified that the injuries were both acute and subacute injuries, meaning that they occurred on different dates, and that the acute injuries would have occurred on the day of death. As to the subacute injuries, there's not a specific date that we can attribute it to. However, that is the reason for the date range. And I believe that would encompass any previous subacute injuries.
Any response?
Stand on the motion.
Motion is denied.
The next four counts, 28, 29, 30, and 31, reference the injury to Layla's buttocks. Count 28, aggravated assault, charges Jennifer on November 17 of 2015. Count 29, cruelty to children, defendant Jennifer, November 17, 2015. Count 30, charges aggravated assault as to Jennifer and Joseph, November 15 of 2017, and cruelty to children in the first degree, charging Jennifer and Joseph, November 15 of 2017. I believe as to counts 28 and 29, the evidence was from Dr. Darasad that the injuries were a few hours old, and I believe the information as to counts 30 and 31, if I'm not mistaken, I might have to go back and look at this, came from Darasad and Dr. Mesner, but if I need to go
Any
back.
response?
There's been no evidence that Joseph was anywhere near the children on November 15th either. To commit cruelty to children against him, he'd have to be present, and there's absolutely no evidence that he was present November 15th.
Motion is denied as to those counts.
The next two counts are 32 and 33. Count 32 is aggravated assaults. Jennifer and Joseph was charged with a date range of October 20th to November 10th. This was blunt force to the child's arm in an unknown manner. And then count 33, cruelty in the first, charges Jennifer and Joseph with blunt force to the child's arm in an unknown manner. The date ranges are October 20th to November 10th on both of them. There were injuries to Layla's arms at the time of autopsy. We're not talking about the fractures, but the bruises. We know from previous testimony from specifically Dr. Duxbury that on 10/20, when he did examine the child, he didn't see any bruises to her arm, which is the reason for the date range being between October 20 and November 10 of 2015.
Any response?
Judge, again, Joseph was not, there's no evidence that Joseph was anywhere near the children at that time.
Motion's denied as to those counts.
Counts 34 and 35 charge both Jennifer and Joseph. Count 34 is cruelty in the first, October 20th to November 6th. This is for fracturing Layla's left arm. Count 35 is aggravated battery, again charging Jennifer and Joseph between October 20 and November 6th, again fracturing Layla's left arm. We have testimony from Dr. Darasaw that those injuries were approximately 2 weeks old. According to Dr. Duxbury, the injury was healing and it was 3 to 4 weeks old. And according to Dr. Manny, it was as well approximately 2 to 3 weeks old. I also have Dr. Evans indicating it was 3 to 4 weeks old. So those are all within that time frame. Could not narrow it any further, but they all agree it was a healing fracture.
Any response?
Same response, no.
Motion's denied as to 34 and 35.
The counts 36 and 37. 36 is aggravated assault, charging both Jennifer and Joseph. Again, a date range of October 20 to November 10, blunt force to the child's leg in an unknown manner. Count 37 is cruelty in the first. Jennifer and Joseph are charged with that date range of October 20th to November 10 of 2015. This evidence comes from the testimony of Dr. Mesner. He had indicated on Layla's legs, specifically in her inner right thigh and the back of that right leg, that there was hypopigmented marks that were consistent with a belt buckle, and that clearly they had to be older than 10 days.
Any response?
Stand on our motion and the previous responses.
Motion is denied as to those counts.
The next two counts are 38 and 39. Both defendants are charged in both counts with a date range of October 17, 2015 to October 19, 2015. It's the same date range for count 39, aggravated battery, October 17 to, I mistyped it. Let me look at the indictment really quickly. Okay, count 38, the date range is October 17 to October 19, and the date range for count 39 is October 17 to October 19. So same date ranges. And this is for fracturing Layla's right leg. We know from the testimony that when Dr. Duxbury saw the child, the visit was on October 20th. According to defendant Jennifer, the injury happened October 15th or October 16th. Christina Lowe saw the child October 19th, so it had to happen before that date. And then Mr. Coppinger said that when he saw the child, defendant Jennifer Rosenbaum indicated the injury occurred October 18th. And then according to Dr. Manny, those injuries, that injury to the right leg was a few weeks old. So that encompasses that date range.
Any objection to 38? I should say responses to 38 and 39.
Same responses by no.
Motion is denied as to 38 and 39.
And count 40 and 41 I'll discuss next, and that is cruelty to children in the first degree is to count 40. Charges both defendants for fracturing Layla's rib between October 20th and November 6th. Count 41 is aggravated battery, charges both defendants to November 20 and November 6 of 2015. And that again is fracturing Layla's ribs. We just heard from Dr. Darasal that was a healing fracture. It was 2 days old, and it was caused by blunt force trauma.
Response?
Same response, Your Honor.
Motion's denied as to those counts.
As to count 42 and 43, it's cruelty to children in the first degree, charges Jennifer and Joseph between the dates of October 20 and November 6. And this charge relates to Millie for fracturing Millie's left arm. Count 43 is aggravated battery, charges both defendants, date range November 20 to November 6th, and they're charged with fracturing Millie's left arm. According to Dr. Duxbury's testimony, her injuries were to the left arm. It was a healing injury. It was 2 to 3 weeks old, and it's not consistent with, according to the experts, is not consistent with an injury in gymnastics with hitting the knee to the arm. So I believe there's sufficient evidence to go to the jury as to counts 42 and 43.
Response?
Same response, Your Honor. Stand by your motion.
Motion's denied as to 42 and 43.
Count 44 and 45 are next. That has to do with Millie again. Both defendants are charged. Count 44, aggravated assault, charges Jennifer and Joseph on about November 15, 2015, caused blunt force to the child's head and neck. Count 45 is cruelty to children in the first degree, charges both defendants on November 15, 2015, with blunt force to the child's head and neck. We heard from Dr. Mesner as well as Ms. Kelly Jimison that those were injuries to a protected area. In fact, I believe it was Dr. Mesner who testified that it is less than 0.2% of cases where that would be an accidental injury, and therefore he concluded that it was caused by blunt force trauma.
Any response?
Just again, there's no evidence that Joseph was present at any of this.
Motion's denied.
As to counts 46 and 47, those apply to Millie. Aggravated assault is count 46, charges both defendants, November 15 of 2015, with blunt force to the child's buttocks, hip, and back in an unknown manner. Count 47, cruelty to children, charges both defendants on that same date, with blunt force to the child's buttocks, hip, and back. We have testimony from Millie that the defendant, Jennifer Rosenbaum, would strike her with a belt. Dr. Mesner testified that the injuries to Millie's right side on that area is consistent with a belt, and it is not consistent with a fall, an accidental fall, or any type of gymnastics injury. So I believe there's sufficient evidence on those two counts to go to the jury.
Response?
Stand by your motion.
Motion's denied as to 46 and 47.
Count 48 is cruelty in the second degree. It charges Jennifer and Joseph between the dates of October 20 and November 15, cruel and excessive physical and mental pain by failing to seek necessary and adequate medical attention for Layla. There's numerous occasions where they failed to seek medical attention. I think the one that came up the most during this trial, and it's probably most prominent on people's mind, is the injury to her leg. That injury, there was a lot of delay in seeking attention, and the doctors testified that that injury to Layla would have been painful. As to, well, I can move on to count 49, or we can...
Continue to 49, please.
49 is cruelty in the second degree. It charges both defendants with, between October 20 and November 15 of 2015, causing cruel and excessive physical and mental pain by failing to seek necessary and adequate medical attention for injuries to Millie. We do know that Millie suffered a broken arm. There was no explanation that was given that could account for that injury. Millie also had injuries to the side of her body, to her hips and buttocks, and she indicated it was painful, it hurt, the bruises, and that her arm hurt when she went to the hospital, and at no time did she ever go to the hospital to get treatment for her arm or any of her injuries.
response? All right, motion for director's verdict is 48-49 is denied, and that concludes our work as it relates to this issue. There being nothing else here at 5:20, let's go ahead and recess or adjourn for the day. We'll come back tomorrow morning, 9 o'clock. Thank you.